Hello. In this clip from our Justia webinar, Navigating and Mitigating Ethical Conflicts in Estate Administration and Planning, Leah Del Percio will guide you about how to handle the different types of conflicts in estate planning that you may encounter during your career. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Okay, so now we're going to touch on how to actually handle these conflicts. So when dealing with the conflict, first and foremost, and I'm being Captain Obvious here, try to avoid potential conflicts. Really just keep in mind when you're working on something or dealing with issues, you're going to want to think about what claims, defenses, issues, and settlement strategies might get raised and what new parties that may impact while you're, representing someone. And if a conflict arises, you're going to disclose all potential conflicts to those clients on both sides, and then determine whether they're waivable or not. You're probably going to want to determine whether they're waivable or not first, then make the disclosure. And then again, both the code and the rules permit a client to waive current conflicts if the consent is, again, magic word, informed, and that lawyer makes an independent judgment that the quality of his or her representation won't be affected. So more detail on how to make that independent judgment on my next slide. So determining whether a conflict is waivable and whether you can truly continue to represent them unaffected is complicated. You have to take your emotions out of it, your desire as a business owner. And any of you, whether you're with a private firm, you're your own firm and you're a solo, you at this point are likely thinking of yourself as a business owner. You're trying to build your book of business. You're trying to get new conflicts. You want to bring in revenue, by any means necessary. And you can't always do that. So you have to kind of check that at the side and that kind of self-assessment. Oh, this won't affect me. And really think, an ounce of prevention here worth a pound of cure for later on. So be your own best advocate here and don't let, your desire to grow your book of business, shade your judgment. So here's some steps you should consider. You're going to want to evaluate the nature of that conflict, determine the type of conflict, as we've talked about here. You're going to want to assess the severity of the conflict. So you're going to evaluate how severe is this conflict? What are the actual monetary complications that could happen in a whole host of scenarios if I continue to represent both parties? And where you're seeing that, and I would do it really as a dollars and cents exercise. Do the math on it in many cases. Think through your job as an estate planner is you're kind of like a professional fortune teller in that you're there to foresee all these issues that could come up. Look at them and look at the actual monetary consequences that could occur. Then you're going to want to consult the rules of professional conflict, look at the model rules, look at the commentary there, look at the state's adoption of the model rules, see if there's any state commentary and look at cases. Really important to do. Then you're going to want to see, well, what's the potential for harm to each client if I represent both conflicting parties? If the harm is significant and it's apparent, it might be that conflict is non-waivable. And that might just be the unfortunate reality of working with people and in being their attorney. But at the end of the day, you can sleep at night and not stress about these things happening, 20 years from now or tomorrow. Next one, waivable conflict. So if you decide that conflict is waivable, here's what's important. And this is common in the intergenerational client conflict situation, which we've kind of been discussing all along. And I'm going to show you how to do it specifically with respect to, these multi-generation estate planning clients that turn into estate administration and trust administration clients. So number one, clearly explain to those new clients, that next generation, those kids, that the nature of the potential conflict due to your representation of that earlier generation, those parents. You want to do that at the outset of the representation. Chances are they're not going to care. They're still going to want to work with you. Your mom and dad's lawyer, they trust you. And usually mom and dad sometimes will, pay or things like that. So they need to understand, though, that confidential information that's shared in the course of previous relationships might affect your judgment or influence your actions in how you guide them on their estate planning. And though, most of the time you're going to see this as, really a situation where, they're I'm trying to think of an example here is where everybody's responsible. Everybody seems fiscally responsible. But maybe while you were doing the estate planning for the parent who has a small business, you learned that one of their kids didn't like the other kid, or, isn't financially responsible, or had a drug habit when they were a teenager that they've since resolved and now they're an adult. That shapes your view of them. You might want to add a spendthrift trust or some protections in their estate planning documents or in their children's estate planning documents. That's information, though, you learned from a prior outside representation of the earlier generation. So these are things you just need to disclose in a general way in your, you don't have to get into specifics here because you also don't want to, break confidences about other matters that you have, but disclosing generally that your viewpoint might be a little colored by the fact that you did represent, others that are related to them, I think is key, and it's critical here. Identify potential conflicts. I mean, easier said than done, but start to think about these things. Think about that prior representation. Think about what you've learned there and how it might color your judgment. That's going to help you really think through, as you're representing that new client when you do waive it, how to keep that kind of in check. It's always better to be aware of these things going into a situation than just turning a blind eye to them and thinking, oh, this doesn't apply to me. This is easy and straightforward. Inform them of the right to independent and separate legal counsel. They have a right to consult with another attorney that's not you, and you need to inform them of this, and encourage them to do so about the potential conflict. In many cases, they're going to waive it, but you want it in writing that you inform them, that they have the option and they probably should hire separate and independent legal counsel to assist them on just the evaluation of this conflict. The waiver document itself, obviously, you're going to want to prepare a document and memorialize this in writing. So if they still wish to proceed with you, have them sign, this waiver document. Again, it should very expressly state this information about their right. Basically, if they sign this, you're saying that you consulted with independent legal counsel about this particular waiver specifically, and about, my representation of, these other family members of yours. And then document everything, every conversation you have with them. Memo the file. I can't tell you how many attorneys do not memo the file nearly enough when it comes to estate planning and administration matters. Just memo things. We have so much technology now that'll create AI memos for you. You can just use a dictation device and have a secretary type it up if you're not into technology. But my goodness, memo everything where you can. Mechanics of these waivers. So waivers of conflicts by the client. So you've now sent them this waiver document that hopefully you artfully drafted. But, something important to note is that, a client who has not, quote unquote, consented may inadvertently waive a conflict. So, delaying for an unreasonable time in an objection to conflict, or can be an objection to the conflict. So important to note there. Them not objecting to it could just be a waiver. Check your state's, model rules that will kind of tell you everything you need to know there. And it may vary from state to state. And then no blanket waivers for all possible conflicts that may arise. Of course, you want to draft a bulletproof waiver document that gives you every scenario, because you're, again, that fortune teller. You're seeing all these unforeseen consequences. But that doesn't mean it has to be so general and so broad that the client doesn't even know what they're signing anymore. And there's a pretty good line in the sand on where you sit. Really deal with just the conflict at hand, not like potential conflicts that could come up, and be direct about it to the extent you can without, expressly disclosing information about the prior client to the new client. So important to note. Elements of waivers. So here's what a waiver should have. Full disclosure. The waiver must thoroughly explain the nature and implications of that potential conflict of interest. This should include how the representation might affect the lawyer's duties of loyalty and confidentiality to each client. Potential consequences. Again, talk about the things that you foresee. That's important. They need to know. Disclose that to them. Voluntary consent. Make sure that that client is saying that they're voluntarily consenting to this. There was no consideration for them to consent to this at all. This is totally separate and apart than the business transaction of you representing them and just something important that they need to do in advance of anything. No consideration there. This is voluntary on their part. Describe the representation. And again, you can get specific there, what matters it's going to cover, and, for what family members. Acknowledge, the acknowledgement of understanding. It should include a statement where that client acknowledges that they've read and understood the waiver, that they're of sound mind, that they understand what they're reading and they've had a chance, again, to discuss it with separate legal counsel, or, they had the option to seek legal advice and they agree to those terms. They should also have in that document expressly the right to revoke a consent. So what you're going to want to make sure they include is like, hey, if this consent doesn't work for you anymore, you've got to let me know in writing. You want to give them a mechanism to come back and notice you, like, hey, yeah, now I don't waive this conflict of interest anymore because, I'm mad at my parents, or whatever the case might be. You need to give them a way to show you that, because again, you're in that position of trust. That's going to make this document more legally valid later on and more rock solid. Them not doing that. Right to revoke the consent, again, I think is pretty important. It also should highlight documents, whether it be in the attached memorandum to it that's annexed to the actual waiver or in the waiver itself. It should highlight alternatives to whether it be joint representation or the concurrent representation, just so they know, like, here's your other options. They need to know, like, them waiving something because they're not seeing any other options is also a problem. And then they should sign the document. As attorneys, particularly in the estate world, we love getting signatures on things. Conflicts and how to mitigate them. So, now that we've talked about waivers, let's talk about, when you have stuff, how we can avoid this in the first place. And again, it goes back to those engagement letters. So one big conflict or one big issue that creates many of these conflicts that exist are vague and seemingly unending duties to clients. As an attorney, your ethical duty to a client, it ends where the attorney-client relationship terminates. That can occur under several circumstances, whether it be completion of the task, which is what you should focus on. That's why I have it highlighted here. Make sure that your engagement letter outlines the task, the scope of the work, and then says when it's complete. So it's very clear where you start and end as their counsel for that particular client matter. The client terminating their relationship, the attorney withdrawing, or the death or incapacity of the client. One thing to note about death and incapacity of the client that I think is particularly important for where we sit in private practice is that duty of confidentiality you have actually extends beyond their death. So it's important to just note that. You might even want to put that in the scope of your agreements and your estate planning engagements, because you can't just go and disclose things after the fact. Those ethical obligations do continue. So now I'm going to walk through a common scenario we see with those attorney as fiduciary situations. That's where the lawyer is the trustee or the executor. And listen, sometimes it's unavoidable. That conflict or that client has no one else that they can trust, and they don't have any family members, they have no friends, and they need somebody to act as their executor or somebody to act as their trustee. And it, can't be their good-for-nothing child or whomever. So you end up getting appointed, even if you don't want to. So the lawyer is the legal advisor to the client, named as the executor. That will contains complex provisions, including distributing various real estate properties to different beneficiaries, setting up a trust for minor children, and making substantial donations to charity. The client passes away, and the lawyer that's now the executor must carry out those will's provisions. The real estate has now depreciated in value. It's potentially impacting the funding of the children's trust that was in that document. As the executor, you must decide how to handle that situation. So, and you're potentially facing a conflict here, even if you don't realize it. So your options include selling the properties as instructed, risking underfunding the children's trust pursuant to the estate plan, postponing that sale, renting the properties and making that estate administration ongoing, or requesting court modification of the will or trust. Each of those decisions could favor some beneficiaries over others, which potentially lead to disputes. The lawyer, if they represent any beneficiaries in a legal capacity, the conflict of interest could further increase. So multi-generational here could be pretty painful. The lawyer now has to balance their fiduciary duty as executor with their ethical duties as a lawyer working on the estate administration, and they might need to seek outside ethical advice or obtain informed consent from all beneficiaries. Again, this is a pretty waivable conflict we have here, kind of a softball here, but it's saying essentially you're going to want to obtain informed consent from beneficiaries about this conundrum that you're in. And hopefully when you've drafted that document, you've given the fiduciary broad flexibility, not only to hire themselves as counsel for the estate. So you want to make sure that that's explicit in the document, that you can use the estate funds as an administrative expense to hire yourself to go and probate the will, because you frankly should hire yourself for this work if you're the scrivener in many cases. You also want to notify, again, that's why the informed consent part is so important, those beneficiaries of this situation that you're in. And what should I do? And then really, what that may come down to is letting them know the potential paths that you take and why you have a conflict here. So just important things to note and really be constantly identifying conflicts of interest. Potential ethical dilemmas. Again, that was sort of a good outline of probably several. One, if the attorney as trustee has to make decisions that it could affect them financially, this could lead to a conflict of interest. For example, as a trustee, the attorney could make decisions about how much to charge for their services if they hire themselves, or how trust assets are divested or are invested and distributed, which might affect their own financial interests. Keeping the trust ongoing, if you're the hired fiduciary, you're making a trustee commission every year. That's affecting your personal financial interests. So looking at your job as counsel as separate from your job as fiduciary, which makes more sense? Maybe it doesn't make sense to keep that trust open. Maybe now a beneficiary has a legal argument. Hey, you're hiring yourself and you're sitting there making money off of this being open, and this could have been closed years ago. You're just kind of setting yourself up for conflicts to occur. So things that are just important to just keep in the back of your mind. Undue influence. There's a risk that the attorney might have been seen, particularly as the scrivener, if they were exercising undue influence over the client. So especially if you're heavily involved in setting up that trust or influencing its terms, which often happens when you're the scrivener of the document. Confidentiality. The attorney acting as trustee might face dilemmas related to maintaining attorney-client privilege, especially because those ethical duties don't die with your client. So you might be privy to financial or confidential information about beneficiaries that could affect their management of the trust or your management of the trust, but that information might be considered confidential under the attorney-client privilege rules. Where does that stop? Where does that end? Again, these are just dilemmas that often have to be navigated very particularly when you are the fiduciary in addition to hired counsel. Your fiduciary duty versus your duty to the client. As a trustee, you have a fiduciary duty to act in the best interest of all the beneficiaries. That can sometimes conflict with your duty to your client, the fiduciary, particularly if you're also one of several beneficiaries. So again, these things can just get hairy. Inadequate expertise. Trust administration is complex. It requires specific knowledge of tax laws, investment strategies, and more. A lot of financial advisory type skills in many cases. If the attorney doesn't have expertise in these areas, say they're a great estate planner and an estate litigator, but they don't have a tax background, or they're not financially savvy necessarily or to the level that the assets of that trust demand, they may fail to adequately protect the interests of the trust beneficiaries. That could lead to allegations of a breach of fiduciary duty. So again, you run into these issues fairly frequently. Multi-party representation. If you're representing multiple parties involved in the trust, like different beneficiaries, there might be conflicts of interest that arise that lead to ethical dilemmas. Other things to note, individuals have the freedom to appoint any person they prefer in a fiduciary role, which means, yes, you can absolutely act as a trustee, an executor, attorney, in fact. And so many of us do. And frankly, it's a service we do to many of our clients that we don't want to do, but we have to because we're in a position of trust with them. The RPCs, they don't explicitly address the appropriateness of this and of you preparing a document that appoints you as a fiduciary. They certainly address the appropriateness of a document that gives you money as a beneficiary. That's certainly addressed in the RPCs, but not you acting as the fiduciary. Lawyers can assist clients in appointing them as fiduciaries, provided that the client is adequately informed, no conflict of interest is violated, and there is no undue influence or improper solicitation. That appointment could trigger conflicts of interest under 1.7 if it risks limiting the lawyer's independent professional judgment in advising the client on the choice of the fiduciary. So proper client information should include the roles and duties of the fiduciary. Tell the client what the trustee is going to be doing. Put it in writing if they're naming you. Even if it's a separate document, it doesn't necessarily have to be the will, but say what these duties are. Tell them about the role of a trustee or the role of an executor so they can make a better informed decision on whether it's even right for you to serve there. Tell them how lay people can serve with professional assistance. That person that they want to name their nephew or niece can hire you as the lawyer to deal with some of the hairy parts. And then give them the comparative costs of appointing a lawyer or a trust company, or any significant lawyer-client relationship between the lawyer, their firm, or any potential corporate fiduciary. So just important things to note. And then lastly, last but not least, since we're coming up on time here, a lawyer's duty of confidentiality continues after the death of the client, as I've said several times throughout this presentation. A lawyer ordinarily should not disclose confidential information following a client's death. However, if consent is given by the client's PR, meaning, the representative of that estate, or the decedent expressly and or impliedly authorized disclosure of that information in order to effectuate that estate plan during the administration, the lawyer who represented the deceased client can provide an interested party, including a litigant, so this is common in state of mind issues with will contests, with information regarding a deceased client's dispositive instruments, the will and the trust, and the intent. Disclosure should be very limited in scope, so you can redact and redact and redact, and limited to the information that the lawyer would be required to reveal as a witness. So you're not going to share the entire estate planning memo on how the client hates their kids and this, that, and the other thing if the question is whether the client had capacity to sign their will. You're only going to limit it to, I met with this client on this day, they seemed with it, and there you go. Big black box, redactions for the rest of the memorandum that you might be brought in to share. Because again, everything else would be subject to attorney-client privilege. So, your duty to preserve the client's confidence, it survives termination of the attorney-client relationship, and it doesn't expire upon the client's death. Disclosure of client confidences could constitute a claim for legal malpractice if the other necessary elements of a legal malpractice claim are established. So just an important note to leave you with and think about as you work on multi-jurisdictional administration issues, whether it be an estate administration, a trust administration, a probate, or any of your estate and trust planning or closely held business matters where you're advising private clients and families. Thanks so much. And now I'll take any questions.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.